Welcome everyone to this webinar on restraint orders and international assets. I'd like first of all to introduce you to the person who's going to be our star guest speaker, Aidan Larkin of Asset Reality. Aidan will be probably very well known to many of you through one of his former roles. He was previously a criminal investigator for HMRC. Then he became Mr. Asset Recovery when he was working for Wilson's, the famous auctioneers from Belfast, and got involved in actually turning assets into reality, realization. And now he's set up as a separate body. He'll tell you a bit more about it when we get to it, but it's very good to have Aidan here. He probably has got more practical experience of dealing with assets than anyone else that I know in the POCA sector. Also with us is Barnaby. Some of you who were at our previous seminar will have heard the introduction then. He's recently joined 5 St Andrews Hill. It's great to have him with us. He's an expert and recognised as such in the brochures and chambers and partners and all that sort of stuff. But particularly importantly for today's topic, in one of his former lives, he had the great misfortune to be based in the Caribbean, working for the CPS in, amongst other things, assisting in the realization of assets or in the restraint of assets in pursuit of UK restraint orders. So he's got personal experience in the foreign jurisdiction, trying to get hold of the foreign assets in support of the English orders. In terms of the procedure, you're going to hear from me with a bit of an introduction. Can we have the next slide, please, please, Tess? I'm going to do a bit of introduction about where restraint orders fit in, and just so because all of the language in POCA is so ridiculously confusing, I think that helps sometimes. Then Barnaby's going to be dealing with the law in terms of how UK restraint orders can be enforced overseas. And that's going to take us to around about half time, we hope. Then after that, we're going to switch to Aidan, and we're going to try a bit of a novel format in a sort of chat between the three of us. But the idea is that Aidan does most of the talking. Now, that's not usually difficult to achieve for those of you who know Aidan, but we'll try and guide him. And what we're going to be doing then is looking at a theoretical case study with lots of different sorts of assets. And we'll be inviting Aidan to give us his experience as to how those sorts of assets can be dealt with. At the end, there may be some time for questions, but what has worked in the past is if you use the chat function, if you want to ask a question, we, the panelists, can see your questions. I think your fellow attendees, fellow watchers, can't see them. So there's absolutely no concern about making a fool of yourself. It may be if you click reply to all or something they can, but if you just say panelists, firstly, you can put in a question without everyone seeing your name. Secondly, I can, as the chair of this discussion, sort of bring things together, draw the strands together, and very often we might have 10 questions all on the same topic. So I can tell if it's something that's popular, and we can consider that. But we'll try and allow about sort of 5-10 minutes or so at the end. But we are quite anxious to finish by 6:30, so everyone can get to their gin and tonics. Well, if we then move to the first topic, please. So this is me telling you about where restraint orders fit in. Next slide, please, Tess. Okay, well, there's the first bit of a little analysis of the sorts of the bits of POCA which deal with restraint or freezing. We're today trying to confine ourselves to restraint orders under Section 41 of POCA. So those are restraint orders in support of potential future or past confiscation proceedings. They are within the criminal section, part 2 of POCA. They are issued by Crown Court judges, and we will try to focus on that. We've got to, however, put them in context, because POCA also has property freezing orders in part 5 in support of civil recovery, interim receiving orders, part 5 civil recovery, account freezing orders, part 5 summary process, Moratorium period, which is when there's been a SAR and your bank has frozen your account, and you, the account holder, can't understand why. And when you ask the bank, they say something completely incomprehensible to fob you off because they're not allowed to tip you off. And that, to most people, is thought of as some sort of freezing order, but of course there's no order at all. And then also there are interim freezing orders, which are in Part 8 investigations in support of unexplained wealth orders. We'll just put a bit more context to those types of orders. On the next slide, please, Tess. So looking again at the different parts, so I'm looking from the other end of the telescope here. We're looking first at Part 2 of POCA. Part 2 of POCA deals with value-based confiscation orders post-conviction, and it includes two sorts of mechanisms. In fact, more than two, but it includes a mechanism to preserve property pending the making of a confiscation order, and I ought to say also pending the enforcement of it. And that's a restraint order, which in the good old days sometimes had a management receiver, but management receivers are about as rare as hen's teeth nowadays, something we might well be discussing later on, and in particular how Aidan, who is not a management receiver, can, through his method of working, achieve very similar results that might previously been carried out by management receivers. POCA Part 2 also has the mechanism for enforcement of confiscation orders, which is through enforcement receivership. And again, that's another topic for another day. We're not going to be dealing with that today. So far as Part 5 is concerned, that's civil recovery for all types of property now worldwide, property freezing order and the interim receiving order. There's the summary process for forfeiture of certain types of property. So that's seizure and detention and forfeiture of cash and listed assets. Account freezing orders, and those of you really up to date will know that a recent amendment by the Financial Services Act 2021, that act we always read when we're looking at POCA, has included accounts at electronic money institutions and payment services providers within the account freezing jurisdiction. That Part 5 also, of course, deals with forfeiture. Next slide, please, Tess. Carrying on through my canter through POCA, Part 6 is the NCA's revenue functions. Part 7 is the money laundering offences, and that's where the moratorium period comes in, which looks like your account's frozen, smells like your account's frozen, but it isn't really frozen. It's just your bank not wanting to commit an offence. Part 8 is the investigations. That includes unexplained wealth orders, and unexplained wealth orders have their own mini freezing orders that can attach to them, and those are called interim freezing orders. So POCA uses different expressions for the different types of order, and we're only dealing with one of those expressions today, which is the restraint order. Next slide, please, Tess. First thing to note, if in doubt, look at the statute. What is a restraint order? Aha, section 41 tells us. It's an order prohibiting any specified person from dealing with any realizable property held by him. So the first point to make is it's a prohibitory order and it prohibits a specified person. So it's an order in personam. The specified person may or may not be the defendant if someone's been charged, may or may not be the alleged offender if no one's been charged. It might be his or her spouse, it might be his or her company, or it might be a third party who on the face of it has got absolutely nothing to do with the defendant, other than the fact that the third party holds property in which the defendant also has an interest. Now, the reason I say in which the defendant also has an interest is what can be restrained is, or what can be prohibited, is dealing in realizable property. And it prohibits a specified person. So the first thing is the restraint order must specify a person. And the second is that the property which he or she is restrained from dealing with must be realizable property. Realizable property means any free property held by the defendant or any free property held by the recipient of a tainted gift. So you can only restrain a specified person who may or may not be the defendant, but you can only restrain the specified person from prohibiting, from dealing in property which is held by the defendant or held by the recipient of a tainted gift. So if the specified person is not the defendant, there has to be joint interests of one kind or another in the property. Property is defined as all property wherever situated. So that means in England, it means in Azerbaijan, it means in the outer stratosphere. And whether property is held, there are rules in section 84.2. All property is free unless it falls within various court orders under section 82. Next slide, please. So this question is, what property can be the subject of a restraint order? Well, the first point to make is that's the wrong question, because a restraint order imposes a prohibition on a person. Property is not itself the subject of a restraint order, a person is. But the person is only restrained in respect of realizable property held by him. And as I said on the previous slide, it must also be held either by the defendant or by the recipient of a tainted gift. So far as restraint orders go, there are generally two types. You can have an all assets restraint order, so that would be against all property held by him, and that you very often get against a defendant. Or it can be all property in which he holds an interest. That's another way of expressing it. It can also be future property. But of course, you can also have a limited restraint order, either limited because there's a limited benefit figure, and let's say the defendant's got a house, the equity in which is easily worth enough to cover any realistic benefit. So there you might have a single asset restraint because that's all you need. And of course, where the restraint order is made against a third party, not the defendant, it will typically only be over the asset in which the third party has an interest. It'd be very unlikely to be against all the assets of the third party. Last slide of, next slide, please, Tess. Here are some examples of realizable property. So they can be things in action. So that's a bank account credit balance, debts owed by third parties, rights under trust. There's case law on each of those. It can be land in England and Wales where there are special rules, section 84.2f. It can be land overseas. It can be chattels, vehicles, yachts, wherever situated. It can then be the exciting things which have made it to the law reports, like racehorses and greyhounds, moving objects which need feeding. In one of the greyhound cases, of course, famously, the management receiver not only had to look after the greyhounds, but had to race the greyhounds at, I think it was, amongst other places, Kings Lynn Greyhound Stadium, in order to keep their value. And the defendant, whose wife was working for the management receiver, looking after her husband's greyhounds, informed the management receiver that she had to go and buy some amphetamine because the greyhounds needed it if they were to have any chance whatsoever of winning at Kings Lynn Greyhound Racetrack. The racehorse case, of course, is also, that went all the way to the divisional court. Those are the fun cases, and Aidan might be able to tell us a bit more about some fun cases, whether theoretical or real, in due course. Also, of course, in the modern world, and again, this is absolutely up Aidan's street, holdings of cryptocurrency wherever situated are property, and so those can be the subject of a restraint order. Final slide in my part now, Tess, please. Making restraint orders effective. Well, section 41.7 says that the court may make such order as it believes is appropriate for the purpose of ensuring that the restraint order is effective. Examples of that are a disclosure requirement. So you tell your subject, give us a list of your assets and what your interests are, and indeed what any third party interests are. Another example is a repatriation order. So a directive to the specified person, usually a defendant, that he must bring or transfer back to England the property that is currently abroad. We call it a repatriation order, but of course, in many of these cases, these assets have never been in England before. So there's no re in it. It's a bring it to the UK order. There are also statutory provisions authorising the detention by police of property which is already seized in 41A. And then there are new additional powers of seizure, 47C, and of search, whereby police can be authorised to search for and seize assets in advance of a restraint order being made. And the restraint order is then made afterwards to capture, if you like, those assets and put them under restraint. There's also, of course, section 48, which has always been there since the beginning of POCA, that a management receiver can be appointed over any realizable property to which the restraint order applies. And that's one of the things we'll be discussing with Aidan later on, about when you need a management receiver appointed under statute and when you just have an asset manager, such as Aidan, who doesn't have any statutory function and isn't hidebound in some of the ways that receivers are. I didn't add there, but probably should have done that, of course, our good old friend, the legislative steer, which is not another type of four-legged creature, but it's a description of section 69 of POCA, is the section which directs the court how to act. And where you have a restraint order made prior to confiscation, the directive is that the court must act in such a way as to prevent diminution in the value of the property under restraint. Again, that's a topic we'll come to with Aidan later on. Well, that's a quick skim through the status and position of restraint orders in the hierarchy of available provisions in POCA. We're now going to move to Barnaby to answer this question: what measures can be taken overseas in relation to making English restraint orders effective? So over to Barnaby.
Thank you, Andrew. And it's great to be here tonight and see so many people have taken the time to come and see us. Now, there are two ways that restraint orders can be imposed abroad and imposed on assets abroad. One is through the actual imposition of the order in the country in question, getting it recognised, and mutual legal assistance. I'll deal with that second. The first and primary way that it is done now, and a move away from the previous aims of POCA, or the previous view that POCA held, is to use repatriation orders. I do apologise if I use the word reparation orders. That was certainly used before. I do not mean that, and I will not get into various issues around that. Having lived in Jamaica, I've discussed many of those over a cold beer. But going to repatriation orders. Repatriation orders are an interpretation of section 41, subsection 7. And under the law and Scarlet versus DPP, it puts the emphasis on the subject to repatriate their assets. This is the idea that they'll keep their assets in a UK function rather than a foreign function. As we'll see, this clashes with certain other principles, but it's never really been tested. And we've seen, from a defence angle, an increase in this over the last 3 years. I'd imagine there will be a number of challenges that go to higher courts. I've certainly challenged it in principle in the Crown Court, but it's never risen above that. The difficulties with it from a defence point of view is if they're not complied with, they end up committing contempt of court. Now, these repatriation orders are linked with disclosure orders. So there'll be a list to disclose your assets, contempt of court if you don't comply with that, and then a repatriation order to repatriate it, usually as long as it's reasonable to do so. And we'll get on to how that works, and also how compliance can work in a way that doesn't cause too much difficulties for the subject. And that is also where Aidan comes in. We will then look, after I've gone through repatriation orders, into restraint orders, how they can be put in place and how they can be challenged, and where you would see them compared to repatriation orders. Tess, next slide, please. So, the DPP versus Scarlet in 2000, in essence, it stated that where there can be a full disclosure of assets put under 41 subsection 7, there can also be a request for those assets to be repatriated. And indeed, most clauses are quite wide, as we'll see. This, from a prosecution point of view, is perfect. It puts the emphasis on the defendant, focuses, makes the defendant do the work, or subject do the work, and also has the iron fist of contempt of court, a civil contempt of court, but still serious prison time potentially, as we've set out in SFO versus O'Brien, behind it. From the subject's point of view, it puts them in a difficult situation. What do? Especially if they are an international businessman, somebody who has majority of their assets outside the UK, what actions can they take? A, not comply with it. B, argue that it's unreasonable. Or C, comply. Now, I would, and as I will go into in detail later, state that the second two options are clearly the best, even if the defendant isn't in the country. He doesn't want to risk that contempt of court, possible extradition, etc. Or his other assets being seized through later action through the restraint orders. Next slide, Tess. The power is on a discretionary basis, so it must be at the appropriate. And as it's without notice, usually it has a time restriction, so there is a certain period of time until it comes into force, or until it can be actioned by the prosecuting authority. Those two clauses both give lines of attack, but also add in, from a prosecution point of view, element of reasonableness. Give us your excuses, give us your time, explain why these are not compliable, and that's what the prosecution are potentially asking, but also giving an opportunity to state. Next slide, please, Tess. So these are the broad grounds for a repatriation order. Again, we have the time limits put in. We have what assets are covered, both disclosure, but also bringing in cash or credit from a financial institution. And sometimes it will be, as well as that, having any assets which are chattels. I've had Veyron, various cars. Andrew asked earlier why every criminal seems to have a Veyron. Alleged was, of course, the term that he meant to put in front of it, but simply because, well, their aesthetics might be interesting, but they're certainly head turners. That seems to be the example my clients give. But as we'll see, should they be included? No. I would say that they're not an asset which should be included under a repatriation order, but there can be other ways that they can be covered, and that's where Aidan comes in. So we can put in place methods of keeping them in status in the country, even potentially having them used, but as long as they're monitored so that they can be an asset for later. And that's where the negotiation comes in, and also applications. It's quite surprising to me that DPP versus Scarlet hasn't been challenged materially since 2000, partly due to lack of use, but also because there has been a lot of negotiation. What I would imagine is that in the next 10 years, as we're seeing an increasing use of these, especially now that restraint orders in Europe are going to be less used in a direct sense, as in enforced in the country, we will see more challenges, and we'll see more and varied guidance given by the Court of Appeal. Next slide, Tess. So, as I mentioned, the two areas of challenge. First, generally, it's not stating it's not reasonable, stating it's fishing, it's too wide, it doesn't, it impinges on the rights of the subject, especially as this is pre-conviction. I don't think that challenge as a whole will get very far, but it will be combined with, for instance, is there any likelihood of dissipation? I think there's quite a good argument there that if these assets have been kept there for a long time, would they be dissipated in that jurisdiction? Should they be dissipated? There is at least a kernel of argument there, depending on the factual basis. The other area is going to be the reasonableness of repatriating the asset. Would it be reasonable to repatriate an asset, especially if an asset has never been in the United Kingdom? Unreasonableness will be highlighted in companies. I had one company in the Middle East. Why would it be repatriated at all? More questionable are cars, other movable assets. And then the easiest to repatriate is money. There might be difficulties in repatriating money, and then there's also reasonableness. Combined with this would also be consulting with an expert like Aidan and saying, what can you do about it? And can you provide services to satisfy the prosecution that these assets are kept, but also allow me to keep and enjoy the assets, or at least keep the value. And that, next slide, Tess, that is option 2. So working out if there is a reasonable second ground. I should say, in combined with Section 1 and Option 1 is the general ways to challenge restraint orders, be it that there's not been full and frank disclosure, that there's not reasonable grounds, there's no grounds of dissipation, or that the restraint order has been on for too long. Those are the classic grounds and the grounds that somebody like myself uses regularly. But those can be combined with overall specific issues in relation to repatriation orders. Next slide, Tess. So that's option 1. That will be the general option used, and as I've said, because of Brexit and the decrease in our relations with Europe or certainly the change in the law in relation to Europe, I think we'll see an even further increase in the use of those orders. But they're not the only way. And if you want to look at how our relations with Europe has changed for letters of request and so on, I can recommend the seminar that Andrew, I and Gary did on that very topic. It is on YouTube, because why wouldn't it be? And why would you want to watch interesting pictures of cats when you can watch us lecture you on that? I'm afraid there is not as many amusing, nice and cute photos, but it is very interesting. And it highlights the issue that our relationship has changed and it is not as easy to enforce restraint orders. When enforcing restraint orders, be it in Europe, be it elsewhere, it's all about the international relationships. And that's something which was highlighted during my work in the Caribbean, but also some of the work I've done in Eastern Europe, some of the work I've done in throughout Europe and even Africa and parts of the Far East. Indeed, it varies greatly and it depends a lot on personal relationships or who has what relationship the office has or the links the office has. So NCA have a great network of officers throughout the globe. The CPS do as well, and all of those assist. I see that Heidi said she missed the previous lecture. That's why it's on YouTube. And we're all going to be there for the next couple of years, which hopefully won't show me aging too much. But the informal intelligence network, the international partners, all something to use. The problem is it depends a lot on that. And it would be very useful if it didn't, but it does. Moving to the next slide, please. There is a question of whether there's an international scope and whether this can be done. In my view, it has to be very precisely worded and has to be sent across, but there is a bit of clash between this and the way that legislation has moved on, but we'll move on to that in probably in our later discussion. Next slide, please. So these are the criminal procedure rules which need to be used for any international restraint order to be enforced. Straightforward. Next slide, please. And we talk mainly about issues, such as it's provisional measure, it's in personam, and you need to know the asset. But the strengths are of doing this, sorry, that didn't make any sense. The strengths of enforcing a restraint order through mutual legal assistance is that you know you get the asset and you don't put the burden on the subject. Especially in very high value cases, it is extremely useful because you know it's in place and you can usually do it without notice. It is a lot of work. It does mean talking to, using the informal networks and making formal letters of request. Also takes a lot of planning and the resources which go into that. But it means that the subject doesn't have the option of dissipation, doesn't have the option of saying no, and doesn't have to have the matter enforced by either later work, hidden assets orders, or indeed contempt proceedings. Next slide, please, Tess. Next slide, please. Next slide. Again, these are just the international assistance and measures. I'll leave you to peruse them in case you like some light morning reading over your coffee. So, practically, and summing up, restraint orders and enforcing them overseas using mutual legal assistance is a very useful mechanism because it allows the state in question to use its own mechanism and own laws to hold that asset in place. But it does mean skirting through quite a lot of different international procedures. It should be used as an exception, and it can take some time. In contrast, repatriation orders are the useful go-to, and they should be seen as a standard, but the matter should be considered in whether in exceptional cases. I'm talking very high value cases, cases where you might need to indeed get a management receiver in, or cases where there are some special cause for concern. But we can talk about that later. And also, if there's any questions now or afterwards, please feel free to email me, Andrew, or I'm sure Aidan. Now, what we'll move on to is the superstar himself, Aidan, to discuss how he can help and solve some of these issues. Thank you very much.
Okay, thank you very much, Barnaby. So what we're going to do now, and now from now on, we've only got, I think, 2 slides left. We're going to have a theoretical case study, and I'm going to be asking Aidan some questions about how his expertise could be used, and I make this clear, for one side or the other, because a defendant very often, some defendants are very upset with restraint orders and don't want to comply at all, but there are other defendants for whom it is very much in their interests that their assets or the value of their assets can be maximised at as early a stage as possible, particularly if, for example, they're in custody and they're going to have difficulty doing it themselves. So it is important to realise that a defendant may wish to have assistance in effectively getting his assets within the scope of the UK jurisdiction, as well, of course, as the natural reaction of the prosecutor who wants to make sure that these can be garnered and gathered in. So our case study, we're trying to make it as simple as possible. So we have an all assets restraint order against Mr. No Good, who's the alleged offender. So that means he hasn't yet been charged. We'll assume for the moment that he's not in custody, but we'll change the facts later if we want to change the facts to put him in custody. Certain assets are known to the police and are specified in the order, and there will obviously be some straightforward domestic ones, and we're not interested in those at the moment. There's also a disclosure order requiring Mr. No Good to list all his assets worldwide, and there is a repatriation order requiring him to bring back any movable assets. Now that's the expression movable assets that has been used for many, many years. And I don't think everyone's ever bothered to think actually, well, what is a movable asset and what isn't? On any view, a racehorse is movable, but only if you kick it hard enough. But a Bugatti Veyron is movable, but only if it doesn't break down. But let's move on from definitions to see what Mr. No Good's assets are. And here they are. So what we're going to be discussing with Aidan are some or all of these assets, depending on how much time we've got. A holding of Bitcoin, a yacht in the Mediterranean, a Bugatti Veyron, of course, in Monaco, a villa or dacha in Ukraine held in the name of a Ukrainian company, a chalet in Courchevel, and I've told people that's France, so we know it's one of our EU former friends, sorry, current friends, but former partners, an account in a Swiss bank, and if we get to on time, a collection of endangered species at his private zoo, perhaps in the garden of his villa in Ukraine. I want to start with Bitcoin because Aidan is Mr. Bitcoin. He will regale us with stories of how he auctioned Bitcoins to drunken Irishmen who paid well over the odds. But Aidan, tell us, how would either Mr. No Good himself or his prosecutor get their hands on his holding of Bitcoin for the purposes of restraint?
Well, firstly, thank you very much for the invitation to join you today. Again, it's a shame we can't do it in person, but this will have to do. I guess the background and the context to all of this is around that we need to look for other solutions. I mean, we all know this 1-2% statistic of asset recovery internationally. There is clearly something wrong with the overall processes, that we have these trillions being laundered and all trillions in criminals' assets being estimated all around the world. But comparatively, our actual recovery isn't great. And one of the things we did with Asset Reality was to try and plug that gap. I mean, for the avoidance of doubt, I'm a huge fan of the use of receivers in the right way. I think they are underused in many cases, that is crying out for their use. And I think that there's a grey area in between that Barnaby alluded to, that we have seen with other countries. I work as a UNODC consultant. I have the pleasure of working with different and training different governments around the world. So we get context. We can see what works in other places. And sort of starting with Bitcoin, it's fair to say that anyone on this particular webinar that doesn't know, I mean, I was sitting in an event in Indonesia 3 years ago when the Australian Home Affairs stood up and talked about the Terezco case, a wonderful success from CPS and Surrey Police to deal with this really complex asset, 295 Bitcoins at the time, and how would you deal with them? And the theme through all of this, from my opinion, as an ex-investigator in the Criminal Taxes Unit in HMRC, they're all complex assets. With talk around regulations changing every day, there is a different headline around Bitcoin and crypto assets. Is it crypto assets? Is it cryptocurrency? Virtual assets? Virtual currency? Digital assets? But they are all regulatory conversations. I mean, for the avoidance of doubt, virtually no country in the world has made changes in relation to the enforcement of complex assets. So good old-fashioned restraint orders apply in Bitcoins as much as they do to the endangered species. And I think that Barnaby's point around getting the defendant to do the legwork, if we looked at the likes of the good news story in the Terezco case, the assets were frozen and the order was varied, 41-7, the court making an order to make the asset recovery effective and make the restraint order effective. For me, we should always be pushing for that. And a lot of people will not agree with me. I know that. If I had my way, every high value asset that was seized, we would be applying, if they were restrained, under 41-7 to vary the order. But we would be telling the defendant that would be the status quo. And we would then look for consent from the defendant. I think if you show someone a path that ends up in a management receiver or enforcement receiver, they will be much more sort of, I'm not going to say malleable, but I'm going to say that they'll be much more receptive to actually dealing with their assets. And like you rightly pointed out, Andrew, I've sat in enforcement court. I've been there when people have been first brought into custody, and some of them want to get their affairs in order. If I'm alleged of a crime and I'm not guilty, and you're about to take my £1 million Bugatti Veyron, the last thing I want is it to be tied up for 3 or 4 years in legal proceedings. But I also understand why there isn't that immediate push to management receivers, and that's not something we're going to change overnight. So we need to look at the grey in between. And what we've seen in countries around the world is excellent uses of consent to get assets sold. So the Bitcoin holding, would we, with Mr. No Good, immediately try, we're going to assume that this his holding of Bitcoin is in a virtual currency exchange overseas. 80 or 90% of the big transactions take place offshore in virtual currency exchanges. So what we commonly see at Asset Reality, defendant is arrested, there's an all restraint order in place, and we find out he has some Bitcoin in a offshore jurisdiction registered virtual currency exchange. Now, we could look down the getting the recognition of the order, things that can take months in some occasions. We can also ask the defendant. And in this particular case, via video link, we spoke to a defendant. Once he was happy that an asset manager was being appointed and we would get best value for his asset, and a lot of these things are pre-confiscation. Once they realize they're going to get the maximum amount of assets, and it will sit and will be waiting on them if they are as not guilty as they claim to be. It's that path of least resistance that I think isn't used often. And actually, my first default on the first point would be go for consent with the defendant, hear what it is they have to say, because you always have up your sleeve the normal timetable of management receivers and enforcement receivers under the 3 conditions that I've got them in front of me. If the defendant sort of either agrees to consent to an enforcement receiver appointed, or they won't satisfy the order themselves, or they don't have the ability to realize best value. virtually all of the cases we're going to talk about will fall into 2 or 3 in those cases. So I think with Bitcoin, I would go for consent first and keep the order up my sleeve if I needed it.
If he won't give you his consent, I mean, there's been stuff in the press recently about the FBI going off on a frolic of their own and getting some Bitcoin in. Do you know anything about that?
So there's a distinction to be made, and it's a very, very common question we get in any of our training. It's something we're actually putting in an expert witness statement on to explain this to the court. It's the big difference between private keys and seizing Bitcoin. And it's there's a great case in Ireland right now known as the fishing rod case, where a particular defendant in this instant, his imagine it's like losing the key to your safety deposit box. If you have your Bitcoin stored in a virtual currency exchange, they hold the keys. In the same way, if you put it in Hatton Garden or you put it in the safety deposit box, there's a master key somewhere, so it doesn't really matter if you lose your key. But with crypto assets, when crypto assets first came onto the market, there was a huge push for people to store and literally keep the keys to their kingdom in their own safe under the bed. And bear in mind, these things can be in paper, they can be QR codes, they can be pieces, they can be words on a piece of paper. So you literally, it's like you're holding that diamond in your hand. And there's a lot of cases like the one in Ireland where they can see on the blockchain that this person has a significant Bitcoin holding. But if you ask him, what is your password? What is the seed word or your private key? And they say, I've lost it. You're just back into the normal hidden assets territory. There's no magic sort of silver bullet with blockchain. Now in Ireland, there was a piece of paper inside a fishing rod that he claimed was the access to his crypto wallet. And when they went to the landlord of the house, he was in custody. The fishing rod case had been thrown out. So now literally in a landfill somewhere, allegedly, is the keys to 50 million euros worth of Bitcoin. But the FBI case was very different because there was a perception that the FBI had cracked the blockchain and were able to brute force someone's private key from them. That's not the case. And again, I'm only talking about what's in the public domain. They accessed the ability to get, I think they were able to get access to the private key because it was held in a server. So just like the criminal not storing it safely, they left it in the drawer. And law enforcement, quite rightly, found it in this easy to identify location. But it is a tricky situation. If you have blockchain analytics that helps you identify a significant Bitcoin holding, or you're searching someone's property and you find a USB key that's a digital wallet, if you can't get access to that and they're sort of taking the fifth and saying, I can't remember it, you're in a sticky position. However, blockchain analytics and Bitcoin and digital assets, unlike any other asset, you can track these assets in perpetuity. So once again, you wheel out the older legislation, you wheel out hidden assets, you wheel out, we will be tracking this in perpetuity, and you make an uncomfortable environment that breeds cooperation. And we've also seen really good results in civil recovery cases, forcing someone to deliver up information in relation to their assets or face sort of other sort of sanctions and other penalties. But there's no silver bullet for crypto assets. It's just like dealing with any other asset.
But a hidden asset, if you can demonstrate that there is a holding of Bitcoin, even if you don't know precisely how much it is, and you can say, well, the defendant hasn't given us the key, whether that's because he can't or because he won't, doesn't matter. Hidden asset finding, please, judge. And he can go and serve the term. And if he doesn't want to serve the default term, he better remember the key quick.
And I think it's worth pointing out for those that aren't experienced with crypto assets. I mean, as an ex-tax inspector, I find it astonishing that criminals still use Bitcoin. It's the most traceable asset in the world. With blockchain analytics software now, you can literally ping IP addresses and you can really get into the weeds of where the person is. So proving it's your person, proving the association with other OSINT and other information and the various digital breadcrumbs that people leave, it's actually the easiest asset in terms of investigation and having a very, very black and white argument. You'll also know if you can't get it, you can't recover it very quickly, but either which way, I would certainly give me a Bitcoin query all day long versus finding a plane that's hidden offshore.
Yeah, well, we haven't got all day, so we're going to move to a yacht that's offshore. So how about Mr. No Good's yacht in the Mediterranean? Let's assume for the moment that it's in a harbour somewhere. How would you, in practical terms, go about getting that?
Again, we can look at the threat of management receivers and enforcement receivers, but in my previous role, we had lots of success by simply going to see the defendant in prison and getting consent. You have to remember that in an overseas jurisdiction, unless you go through those very long and costly hoops of getting some sort of mutual recognition, what they really want to see in those jurisdictions is some sort of appointment document. So we can be that grey asset manager in the middle. And if we have the signature from the defendant, if we have some sort of deed of ownership or a registration somewhere, a registration document that says Mr. No Good owns it and he's appointed asset reality, well, we don't need anything else. Now, I would probably want the insulation with a complex asset of a variation order to very specifically lay out this is what's going to happen, but we have the consent of the defendant. And again, those things can move very quickly. I can thinking back to success stories in the Eastern region, for example, where we had consent on a yacht that was sitting overseas, and the whole thing moved very quickly. And within 60, 70 days, the asset was recovered and sold. Order was varied. So there's lots of examples of that in the past. And if you're sitting in front of someone in prison and you want to get their consent, if they know that you will push on with a management receiver or enforcement receiver, whereas in my experience with defendants, they kind of think that there's not always that consistent approach to enforcement, just simply because of lack of resources and lack of understanding, and countless other reasons. It's not a criticism of anyone or any entity in particular. But I think a firmer hand and a firmer process will encourage more consent, and the yacht should be easy.
You mentioned selling the yacht. Would that be with the consent of the defendant, or would you try and get the judge to order that instead of putting you on board in Monte Carlo and sailing it back round through the Bay of Biscay, back and putting it in Southampton for a bit and costing a fortune in mooring fees, that it should be sold? I mean, in theory, the judge could order that if it was necessary to prevent dissipation of assets.
It goes back to my first point. I think that in a perfect world, if I look at the Netherlands model, and I appreciate it's not the same legislation, but if you're thinking about the alleged victim or the victims of the crime, I think we should be much more assertive. Look at normal insolvency cases. Assets are taken out of your custody, automatically vest in a trustee, and they do what they need to do. I think we're too soft with criminals and confiscation orders. I don't think we throw the book at them enough in terms of the tools that we have available. So I would be pushing for consent initially because it's the path of least resistance. And if not, get those orders. But you're right, the additional formalities then can lead to further conditions that need to be satisfied. We can just make the process more complicated. But I mean, there's not an asset there that I see that we cannot take in that informal approach to begin with and then use the tools as we need them.
Okay, let's move on to the Bugatti Veyron, probably fairly similar to the yacht. I suppose you need the keys.
You need the keys, and so other considerations around. I mean, the UNODC has very good guidance that was published in relation to 14 non-binding guidelines for best effective asset management and asset recovery. So the real practical issues, and number one of that is pre-seizure planning. And I think we sort of missed the main point in all of this, is that all of these things should be considered pre-enforcement. Before you even seize the asset, have the conversations. How are we getting our hands on this asset? If the stars align and we find the Bugatti and we know it's in Monaco, how are we going to get it? Because we can factor that in. And the Bugatti, other things like VAT considerations, if you move it out of the jurisdiction, there's a lot of conversations that only take place at the very end of the proceedings, when I think they should be a bit more front and center, because they will inform your strategy. And we've also seen cases, for example, Bonham's had a very famous auction of the son of the Equatorial New Guinea. The leader there, I think, had a supercar collection that was seized and sold in Geneva. But after the auction, it transpired that all of the service books and things were missing. And then if someone else pops up out of the woodwork and sells them on, even knowing that when you're securing those assets, to look for those documents. On a £1 million supercar, service records and documents will add 10 or 20% in some cases. And VAT documentation on the yacht immediately will discount 25% off the sale price. So there's lots of realization considerations that should be factored in pre-enforcement.
Christine, who many will know is a very experienced management receiver, has asked, what does Aidan do if the asset is held in a name other than the defendant?
And that's where we come into the receivers, and where I said at the very beginning, I think that surgically, when that corporate veil needs to be pierced, when you need that protection, it's very easy to hypothesize in these straightforward cases that you could just appoint an asset manager or appoint an auction company or an estate agent. But where those other complexities come in, that's where we're out. That's where there is that additional layer of difficulty, and where enforcement agencies should be making use of experienced receivers. I've worked with Christy many times, and having that comfort. Trust me, in a perfect world, I would take all my instructions from a receiver and have that protection that we know exactly what we're doing, and we're not doing that running about. But I think when we look at the current landscape, when there aren't those amounts of receiver appointments, we need to try and plug the gap, because otherwise the Bugatti will sit in Monaco for 3 years. The yacht will sit in the Mediterranean and depreciate. We've even seen in cases as large as the 1MDB case, a $200 million vessel, with the US Marshals, the DOJ, the internet biggest anti-corruption case in the world. That still sat for 16 months at $500,000 a month in storage. That, by all intents, everyone admits could have been avoided. So I think there still needs to be that sort of choreography, but in a perfect world, you would want that strategy discussed, what is the best tool for this particular job? And if we cannot get that easy low-hanging fruit with a single consent case, then straight away I would be pushing for the receiver.
Let's move to the villa in Ukraine, held in the name of a Ukrainian company. Let's assume for this purposes that Mr. No Good is not going to cooperate with this in 1,000 years. Obviously, you could use the international provisions to get your restraint order registered in the Ukraine county court or wherever, and ask the Ukrainians, under whichever international treaty applies to them. I can't remember which one, but someone like Louise will probably bounce up and know immediately which it is. But let's assume there's some sort of treaty with Ukraine. Obviously, you could do it through legal channels. From an asset management point of view, if you haven't got a cooperating defendant for this sort of asset, is there much that you can do?
And that is where we know our limits. I mean, that is where you need the experience of an enforcement receiver or insolvency practitioner, and sort of with good legal advice. I mean, Asset Reality actually is the current technical advisor on asset management for the Ukraine, and this is a major problem where assets are being taken into custody by the state, very costly and expensive assets, and the complexity of trying to realize them just means that the returns are disproportionately low versus the overall. You're talking about things of essential key infrastructure like power plants, for example. So the likes of those assets, we would know, we know where our expertise starts and stops, and that's why I would always be bowing to the greater knowledge of the receivers and lawyers in those cases.
Right. If we move closer to home in the chalet in Courchevel, obviously until Brexit Day, we would have had mutual recognition of our restraint order by the French authorities. So subject to a few formalities in France, it would already be bound and the French authorities would assist. Since Brexit Day, we now have the wonders of the Trade and Cooperation Agreement. And when we turn to page 1378, we will find the relevant part for how the French will give us their best measure of assistance. But it won't be mutual recognition. Again, I'm rather assuming, Aidan, that from your point of view, there's probably not much more you can add to that.
No, and like I say, we've seen similar cases where, with the consent of a defendant, we had cases again, excellent cases in the Southwest region, where uses of a compliance order, for example, to compel the defendant to give us the practical things that we need to sell a property. So if it's a straightforward property, and the
compliance order is only after the confiscation.
But we're talking about sort of practical tools in terms of, we had a villa in Spain, for example, where all you really need is the keys, and you need different things signed for notary documents. Sometimes some of the practical steps, we've seen really good use of compliance orders. But again, in this case, if we don't have the defendant's consent, it would be over to the experts.
The next one is an account in a Swiss bank, I want to change the facts here a bit, because let's assume it's not a bank in Switzerland, but a bank in a country which has exchange controls. Let's suppose Mr. No Good says, I've got $1 million in my account in Burkina Faso or wherever, but there's an exchange control in Burkina Faso which says, although I've got £1 million in the bank and I could go and take it out in Burkina Faso and spend it on wine, women and song in Burkina Faso, I'm not allowed to transfer any of it, save to a limit of $1,000, to the UK. Could you do anything to help Mr. No Good repatriate that money, getting around the exchange controls, brackets lawfully?
Lovely. glad you added that. So again, I'm not going to try and bluff and say, yeah, that's something we do regularly. The closest thing we can come to this, and it would the direction I would certainly head in, is conversion, because we have a very similar situation now emerging with cryptocurrencies, where you have a particular holding of one cryptocurrency that is maybe illicit or banned or is a privacy coin. and in which case what you're looking to do is convert it into something that is acceptable, and then using that as the vehicle to send back. So we've seen cases where Monero, the privacy coin, has been seized, and the insolvency practitioners quite rightly are saying, well, can we convert this to Tether or a stable coin and then get the value out that way? So before consulting a receiver or Barnaby or your good self, I would pose the question, can it be converted to another category? Could you convert it to Bitcoin and send it back?
I suppose you could go to Burkina Faso, use that money to buy yourself £1 million worth of crypto, and transfer the crypto to England, because there's no exchange control on crypto.
So you're allowed to do that, and allowed to, it's the hurdle is that initial conversion. But for me, again, it's certainly the path of least resistance. If you can get the asset converted, turned to Bitcoin on an online exchange, and sent back, the fees are minimal for that actual conversion to take place.
Finally, and there's a bit of fun in this, but a bit of a serious side as well. But Mr. No Good's got his private zoo, and he's got some nice CITES endangered species. And he says, by all means, put them in a crate, stick them in the bottom of an aircraft, and fly them, and ask London Zoo to look after them. Obviously, we've had cases with HMRC where the endangered species have been seized in the UK, and that's happened. But here, of course, you'd need a CITES permit to transport them from wherever they are in the private zoo to the UK. Could an asset manager apply for permits?
So it's something I've done in my previous life, actually, at Wilson's Auctions, where we've been appointed on sort of petting zoos that had exotic animals and endangered species illegally held there. And also even in proceeds of crime cases, where we've had a very famous sort of sci-fi case in Wiltshire, which was all over the press, and a phenomenal case with sort of all sorts of movie memorabilia, the actual screen-used car from Back to the Future 2, but also capuchin monkeys and some other interesting animals and assets. So in that case, we've seen that again, that's where we're relying on, does the value justify a management receiver or enforcement receiver? Because again, I wouldn't feel comfortable getting involved in a substantially expensive asset without that protection and that expertise. But we have seen again in the lower hanging fruit and lower value assets where we're making use of consent plus a variation of the restraint order to give you that protection. So in the case that I was actually involved in, because there wasn't a huge monetary value in the animals, it was more a case of, from a welfare point of view, finding a sanctuary that would take the animals. So when we identified a sanctuary, it was in Dublin. So we had to obviously cross a border. So in that case, we then had to make applications and go back, and again, through the financial investigators and others, able in CPS, able to make those applications in the actual I think it was in the variation order, that there was stipulation as to what would happen. A lot of these things that take place, there are regulations, and that's where you would need to bring in sort of, like you said, CITES is the very common one with things like any primates or endangered species, where you would then obviously have to get legal advice and to make sure that you don't put a foot wrong. So in the likes of those cases, I would definitely be leaning towards the expertise of receivers for that legal coverage, unless there was really no value in the assets.
Well, in answer to my question, Louise pinged back virtually immediately that the International Convention for the Ukraine is the Council of Europe 2005 convention. So I've forgotten that Ukraine is the Council of Europe. I think there are quite a lot of countries that are members of the Council of Europe. I think Russia is, but how cooperative they all are, I'm not so sure. Aidan, one thing I know that you're aware of is that the Law Commission have been conducting a consultation, and it's now beyond that stage, where they're looking again at confiscation, and they had some quite innovative ideas about, in broad terms, I'm going to call a trustee for asset recovery being appointed at an early stage. I think they've somewhat gone back from that. The initial consultation was very daring indeed, suggesting effectively that upon a restraint order being made, all the assets automatically vest by order of the court in a trustee who then does what he likes with them. They've gone back from that, but give us two sentences. What would you ask the Law Commission to recommend for improving the prospects of asset recovery in restraint order cases?
I would meet them halfway. I am an advocate. I think they missed an opportunity. I would much rather have Christine and her insolvency practitioner friends appointed on cases. It's the best practice in every other country in the world where there's a receiver appointed who makes decisions on depreciating assets. I do not believe it's interference with property, and that's my own personally held view, because I think that what is the cost of inactivity? We don't appoint a receiver on the case, and we let the Bugatti sit for 5 years. And every police force is subject to this. We have cases where we see assets sitting all over the UK and all globally. It's not just a UK problem where assets are not sold fast enough.
How would you fund it? How would you pay the receiver?
I think
it's all point for the CPS.
Yeah, but I think that, I mean, think of any other, the template exists with insolvency cases. I mean, every insolvency case where assets are realized, the receiver's costs do not outstrip the assets. Things like percentage, realizations and scale rates, but also just having that blend of what's the low-hanging fruit, what can be dealt with via consent and can be sold quite quickly, will reduce the receiver's time spent on the case as well. But I want to make that absolutely clear. I think that we've missed an opportunity. I think that receivers should be automatically appointed at the very least when a confiscation order is granted, or the threat, if you do not consent and have your assets sold in 30 days, a receiver is being appointed, I think would speed up the process.
Right. Okay. Well, that's taken us just over our hour. Are there any questions anyone else wants to fire in on the chat function? We've been dealing with most of them as we've been going through. There aren't any outstanding ones at the moment. Something funny has happened to my slides, but I think are we all still there?
Yep.
Any further questions that anyone wants to add on the chat function? Well, they've reached the gin and tonic rather than reaching for the chat button. I'm not going to prolong it. Perhaps the reason for the questions is that we've got some great nice compliments instead. So instead of a question, we've got great presentation from Ophelia and from Kate. Thank you very much. That was very helpful. I hope what we've done is managed, first of all, to provide a few answers, but from the experience of the names that I know of our attendees, most of you probably knew this already, but also to put some practical flesh on the skeletal pieces of law, which are almost inevitably to be found in POCA. So what I'm going to do is thank Aidan in particular for joining us. As Tess, as I think, told you all, in due course, if you access via our website, you can get the slides and or the YouTube presentation. I don't think any of us have said anything out of turn, so I suspect we won't have to edit it too much. Thank you also to Barnaby, and thank you for Tess for running the show remotely. I really hope that the next time we do one of these, we'll actually be able to meet, but fingers crossed. So thank you very much to everyone for attending.